Okay, y'all, today I'm going to start right off by telling you that we have 3 judges in Canton, Mississippi who are gagging, smothering, and robbing minor children's inheritance by funding their own trust accounts. This is what our judges in Canton, Mississippi did and are still doing to my children. They knowingly aided and abetted attorney Todd Burwell, attorney Richard Eisenberger Jr., attorney Jeffrey McGuire, and Tom Pace, executor for the Will Pace estate, and Marita Pace Walton, executrix for the Jim Pace estate. They aided and abetted Tom and Marita, the judges did, in stealing my children's inheritance, of which is, including from the estate of their grandfather, Dr. Pace, well over $3 million. I can't know the exact amount since they have been robbed. And they are funding several criminal trust accounts. One is named Blue Skies Investments, LLC, at BankPlus, which they themselves are all beneficiaries of. And this Canton, Mississippi court called full court press on me from before the time Will even died. Since these judges are the referees, they keep calling technical fouls against me for just asking questions and trying to get back my children's stolen inheritance. Yes, you are not hearing things. This is fact. This conduct is going on against me by the judges in the Madison County Chancery Court, by 4 different fraud attorneys I was paying and just begging them to help me all along the way, by my own attorney brother, Alan Woodard, who was in cahoots with Todd Burwell and these judges, and he's in cahoots with all these judges and with the estate attorneys in BankPlus in Yazoo City, Mississippi. Brother attorney Alan Woodard has not only benefited from the robbery of my children, but he robbed me of over $1.5 million of my inheritance, being my 1/4 of our mother's farmland in Yazoo and Sharkey counties in Mississippi. Right now, he owes me over $190,000 in farmland rent, not to mention the $1.5 million for the land itself. Who knows what else you robbed me of, Alan, while Mom couldn't know any better and after she died? Alan, you were unbelievably rotten. Ray Ray, Ma, and Mom are rolling over in their graves, and you know it. So anyway, I'm going to start talking about what led up to me firing Cody Gibson, and about my new fraud attorney, Tabitha McCall Stern, and about what happened at the summary judgment hearing. I mean about what Richard Eisenberger Jr. and Judge Robert G. Clark were doing there at the hearing. Lastly, I will tell you exactly what criminal attorneys Todd Burwell and Richard Eisenberger Jr. were actually doing a few days after the summary judgment hearing. At the same time, what Eisenberger was mouthing off to McCall Stern about. And lastly, I will tell you and show you about McCall Stern's fraud scam committed via robbing my identity with the assistance of BankPlus in Yazoo City, Mississippi, and the assistance of the Chancery Clerk's office in Canton, Mississippi. So let me start on April the 17th of 2023. I told Gibson, my attorney at the time, regarding the motion for summary judgment, it just feels like you are on cruise control. Therefore, I'm alerting you to my plan to speak to Judge Clark on June the 1st about forcing Tom, the executor of the estate of Will Pace, to pay me back either via the estate or via the life insurance proceeds for expenses for the kids, and to ask him to order that. And that he order that Tom continue to do so until Judge Clark enters his order on my motion for summary judgment. So Cody told me, no, you cannot do this because this motion is strictly a legal argument. I said, but this is also a legal argument. They're in contempt of court for this brazen breach of contract, right? So Gibson said nothing back to me. So let me explain first that Will Pace was the named beneficiary of the Jim Pace's personal property and residuary estate. In other words, a ton of things from big to small. But on April 25th, 2023, it occurred to me that Jim Pace's other beneficiary, Celeste, who inherited Fox Hollow Place, Nicholson Place, Potlatch, and Flying J, was also arguing, get this, the estate of my children's grandfather, Dr. Pace. You may wonder who is representing the estate of Dr. Pace. Well, lo and behold, it's none other than our very own Tom Pace, Todd Burwell, and Richard Eisenberger Jr. They are arguing over a John Deere tractor, tractor implements, a mower, a leather sofa, a desk. Who knows what else? Because Doc, not Jim, had paid for all of this, but he had left this stuff on the property at Fox Hollow Place so that Jim could use it there, which Jim bought the Fox Hollow Place from Doc in 2018. So at this point, I'm realizing, well, wait a minute. If Celeste wins this motion, then the tractor and the mower, the implements and the desk and all the other stuff, then this stuff is my children's because it's residuary. So I told Gibson this, and he said absolutely nothing back to me. So Jim's other beneficiary, his girlfriend Celeste, had probated a last will and testament for Jim in Madison County Chancery Court in December of 2022, right after Jim died in Memphis. This last will and testament was contested by Dr. Pace and Will Pace, and Judge James Walker deemed it invalid and set it aside. But it included a more detailed list of Jim's personal assets. On May 15th of 2023, I asked Gibson to request the full inventory that McGuire had done in person, because for one, this accounting and inventory stated the reason for the full inventory not being included herein is because the only items listed below are in dispute by any party to this matter: the tractor, the desk, the mower. Remember, I am a barred party to all estate cases that my children are beneficiaries of because they are robbing them of their inheritance. Anyway, on May the 16th of 2023, still years from knowing what they did, I emailed Marita and I said, I'm attaching 2 documents: the will that Celeste put forth, which was contested and later deemed invalid, and the accounting and inventory done by you and filed by McGuire last month. I told her that after review of the invalid and set aside last will and testament of Jim Pace's, that I have cause for concern regarding proceeds from life insurance policies Jim owned. A thorough investigation of this is warranted and is requested by me. I am further concerned about inappropriate goings-on with this money. I said, Marita, I am requesting all life insurance policies in beneficiary forms. I want clarity and peace of mind. Let me know if you will subpoena this from all life insurance companies where Jim had policies. 0 response, of course. So I emailed Gibson about my concern by saying that Jim's girlfriend, his other beneficiary, had paid some lawyer in Memphis to type up a last will and testament on Jim Pace as he was actively dying. He had suffered strokes, heart attacks, collapsed lung, sepsis, and even blindness. And this attorney in Memphis faxed this last will and testament up to the hospital floor where Jim was dying. It was the COVID floor, and had a nurse walk it down for him to sign. Let me show you that signature, and you'll know automatically. Here. So, given all this, I told Gibson to do what he needs to do in order to uphold the testator's intent for the sake of Will and for the sake of Will and my children. Then, after that, I forwarded all of this to Alan Woodard and asked him, what do you think? He never replied to that. That non-responsiveness was not normal behavior. So on May the 17th of 23, I am again getting crickets from Gibson. So I emailed and I asked him, what is your problem? I said, the Jim Pace estate case is my case. That I have no trust, 0, for Tom Pace and Marita Walton. It is the law that I know everything going on in the Jim Pace estate, and I need you to start acting like it. I should not have to subpoena anything, but go ahead and subpoena the hell out of them. Get Jim Pace's full inventory, get on the horn, and find out who his life insurance policies were with and subpoena those. Just subpoena his bank account statements, for God's sake, and you'll see the auto drafts. That will tell you everything we need to know about those life insurance companies. I then told Gibson if he does not have time for this to let me know so I can find another attorney. Gibson responded that with his public defender job, he is short on time. So if I want to go ahead and find someone else, that he'll give them all the information he has and help any way he can. So I responded, this is all so upsetting. But on May the 19th, I told Cody it's been 9 months since Will died and that Tom Pace has not listed Will's house for sale, and that I think it must be only because he is so enraged at me over the breach of contract complaint that he wants to avoid the estate receiving any money so that he can avoid me getting any money. Cody stated the issue with the house not being for sale is that even if it is sold, the Will Pace estate is still insolvent. So again, I'm like, what? That makes no sense. None. So I'm more confused. But that was not why, of course. It was because these people, Burwell Eisenberger, Judge Clark, Alan Woodard, Barry Bridgeforth, Marita, and Tom were waiting on fraud checks from Old Republic National Title to arrive and then file all these fraud papers in the Madison County Chancery's clerk's office, which I uncovered in June of 2025 due to their own stupidity along the way. I mean, everyone's behavior was more and more weird and making me more and more suspicious. I showed you one insurance scam on my last episode for totaling $800,000 with BankPlus in Yazoo City, Mississippi. And at the end of this episode, I'm going to show you another one done in my name by robbing my identity and Will's identity to benefit my second attorney, McCall Stern, and all the other fraud shareholders. Just so you know, I also have fake deeds of trust on me from JP Morgan Chase and Trustmark National Bank. So it's not BankPlus, it's all the banks. So anyway, Gibson was busy trying to trick me at this point to agree to this proposed order Eisenberger had drummed up to deny my motion for summary judgment. I told him that regardless of what Eisenberger types up, his trick is going to fail because I'm going to my hearing either with or without you. That I'm going to tell Judge Clark, come hell or high water, I'm going to talk to Judge Clark and tell him about everything. Anyway, on May the 19th of 2023, Cody, playing on Team Tom Pace, informs me that he did a bad job of explaining what summary judgment is. That a summary judgment only deals with a matter of law without undisputed facts. That although this is the case, we still cannot move forward due to case law. Cody attempts to shove in my face some case sent to him from Eisenberger titled Biloxi Regional Medical Center Incorporated versus Estate of Ross, 1989. Citing that the issue in this case is that the Ross estate was disputing a probated claim for medical bills which the estate of Ross alleged were not duly owing since the services performed at the hospital were performed on a dead body, therefore were unnecessary. Okay, that's really like my claim. Okay. Furthermore, Cody warns me that if we go forward with this hearing, that Burwell and Eisenberger will get to bill the estate, which will be money coming from out of my children's inheritance. Gibson proceeds to attach this proposed court order to deny my motion for summary judgment, citing the motion is improper procedurally, and Judge Clark will deny me based on that. I wrote back, no, I'm not agreeing to this, and you can sign that in ink, Gibson. So he said, well, what would you agree to? Is there some issue with this proposed court order to deny the motion? At this point, I'm thinking Gibson is either the stupidest person on earth or he's behind my back taking bribes. But I had not reached the point of bribery, so I was thinking he's just stupid. Anyway, Gibson again tells me that there is not much, if anything, that he can argue for summary judgment, and there's nothing that will change this fact. And he understands that I'm frustrated, but after looking at Biloxi Regional Medical Center Incorporated versus the estate of Ross, the probability of me winning our motion is poor. I told Cody, I'm sick and tired of you. You are doing exactly what Eisenberger is telling you to do, and why is that? And on top of that, you're playing easy come, easy go. So anyway, why did you bring the motion in the first place? For the last time, Cody Gibson, this is a clear-cut matter of law with zero genuine issue of material fact. But since you are refusing to help me, I'm going to my hearing alone and I will argue this motion myself. Cody replied back to me with his same nonsense about this motion being procedurally barred. I replied back, I am going to court. You stay put. I'd rather not have you there anyway. You're messy. You will mess me up. Cody comes back on the intercom and tells me his duties as counsel include giving me a candid assessment of the situation to get the best outcome possible for me, and that his duty is to me and me alone, and that I should do as he advises and agree to deny my motion. I said, Cody, no, let me get real candid with you and let me advise you of something. You need to take your case law and your procedure somewhere else, okay? Because it's not going to fly here. Cody responded that at this point he thinks he needs to withdraw, especially since this has become so personal to me. I wrote back, okay, good. And that, you know this, Cody. You know it already. But whether or not the estate ends up holding $1 million is not even at issue here. That will not change the fact that I have a legally binding contract, which we all see them breaching in broad daylight. So you stay home. I am done with you and I'm going to my hearing. So get this, okay? So now I'm calling Alan, the attorney brother in Rolling Fork, Mississippi. And I'm asking him to meet me there at this hearing in Yazoo City and to just argue this simple motion. Just come on. He confuses me and he says he can't do that. I said, what? Why not? He says he does not know what's going on in the estate and can't argue this motion. First of all, Alan, you don't need to know anything about this estate because this is not an estate complaint. You know that. Second of all, Alan S. Woodard, actually, you do know everything that is going on in the Jim Pace and the Will Pace estates because you have been assigned a membership into my children's inheritance. So back then, though, I was just sitting there with this funny feeling over Alan refusing to help me. I'm just thinking to myself, this is not normal. It's just not. But never would I have dreamed he was drumming up assignment of membership interest for himself off the stolen inheritance of my children, his nieces and nephews, for God's sake. On May 22nd, 23, Gibson threatened that because Eisenberger has advised him that he will seek attorney's fees under Rule 56H, which reads that if the court finds that the summary judgment motion is without reasonable cause, it may award attorney fees to the prevailing party. Gibson tries to stop me from proceeding to my hearing by telling me, Kate, this means against you personally, not against Will's estate. I just said back, I'm going to my hearing, Cody. So on May 23rd, 23, enter Tabitha McCall Stern. My first email to her reads, the other side has been going full force, full court press to keep me away from seeing the judge in all matters. McCall just responded, okay, we're going to get a freeze on that life insurance money immediately. I said, okay, well, thank God. On May the 31st at 10 p.m., docket 33 was filed in Madison County Chancery Court. This was my reply to response in opposition to motion for summary judgment, reply to Eisenberger. At this time, Stern was unaware that the court itself was robbing my children's inheritance and robbing mine, and were beneficiaries themselves to the stolen money. So that morning on June the 1st, Stern picked me up at 8 a.m. we drove to Yazoo City, Mississippi. On the way there, she told me that she had talked to Eisenberger last night and that he was acting really weird. And she was thinking to herself, what is the deal with him? This is just a case. Why is he acting so weird? So during the hearing, I am glued to it, of course. So Judge Robert G. Clark III knows everything as he's sitting up there on his throne. And he knows I have been trying to bring this matter to court for months. So he is actually playing with me. This is how just horrendous this is. Clark knows full well he is not going to ever even going to rule on this motion, much less fashion any ruling in my favor. But Clark is sitting up there playing with me by putting fake heat on Eisenberger at this hearing in order for me to get my hopes up. What Clark was doing was questioning Eisenberger's argument in a way to make me think, well, thank God the judge isn't buying any of this nonsense. What Robert Clark was doing, he was making Eisenberger answer stupid questions. This was being done to give me a sense of relief, to make me think he was on my side here, just so that he could turn around and smack me in the face, making me more upset than ever by never even entering an order on my motion for summary judgment. To this day, there's no order on it. The last thing Clark said, though, on Thursday, June the 1st of 2023 was a big lie, and he knew it. He said, I will have an order entered by Wednesday, knowingly lying in order to cause me further confusion. On June 15th of 23, Stern, still acting in good faith, forwarded me an email conversation she had had with Eisenberger saying, I have not received a response regarding the disbursements to Kate. Please advise. She wrote that to Eisenberger, If I do not receive a response by the end of next week, we will have to file a declaratory judgment or other motion to compel disbursements from the court. The next day, on the 16th of June, Eisenberger responded to that email to Stern by saying, given the fact an order hasn't even been entered on the motion for summary judgment, it's unfortunate that you are threatening to further pepper the docket with needless motion practice. Frankly, it's completely unnecessary and will only continue to drain the limited assets of the estate and the life insurance trust account that are intended to be utilized for the benefit of the children and not for Kate. So, no, Rick, neither you nor Tom nor anyone aside from me was this money intended for, no matter how hard you try or how much you lie. The life insurance policies, mine and Will, were to be kept until the children obtained the age of 21 in order to assist in their support in the event that one of the parents passes away. So Stern replied back to Eisenberger and said, what Kate is asking for is for the benefit of the children. The status of the Will Pace estate has no bearing on the life insurance money. Kate needs to be able to support the children now and cannot wait merely because Tom Pace is in opposition to this. The clear intent of Kate and Will's property settlement agreement is to require life insurance to assist the other parent in supporting the children during minority. Eisenberger goes on to tell Stern, Kate's fixation on pursuing endless litigation against both the life insurance trust account and the estate is completely abhorrent. He said, clearly, Kate has lost sight of the fact that she is not personally entitled to receive any funds whatsoever. All Kate is accomplishing is reducing the amount of money that her own children will benefit from, a fact she either is completely ignorant to or she is willfully ignoring to her children's detriment. Eisenberger continues, if Kate continues to elect to file motions and set hearing dates, we will continue to request sanctions and attorney fees. What is more, we will seek to have all the attorney fees incurred related to defending against Kate's claim assessed against her when the estate is closed, which is unfortunate because it will, again, only reduce the amount of money the minor children are otherwise entitled to receive. What is he talking about here? Is Eisenberger talking about what my children are entitled to receive when I die? I don't know. Anyway, he finishes up with, to that end, I hope Kate can muster the patience needed to allow us to focus on selling assets of the estate, determining the solvency thereof, paying valid creditors' claims, and closing the estate. At this very moment, let me tell you that Eisenberger is typing this, that the very moment he's typing this email, let me tell you what he, Todd Burwell, and Jeffrey McGuire are up to at 124 1 Madison Plaza, Madison, Mississippi, are up to. they are preparing assignment of membership interest in Blue Skies Investments, LLC to themselves. So Blue Skies Investments, as I said before, is my children's inheritance from the Jim Pace estate. Not only is this 100 Mansdale Park Drive, but this has turned into the LLC that holds all my kids' cars from Jim, guns from Jim, and likewise other items, tons of other items. But Burwell and Eisenberger and McGuire, Marita and Tom stole from them through the Jim Pace estate. So we have docket number 88-1, which is the Burwell and Eisenberger filed attorney fees invoice. They filed this big book of dark evidence of all this I'm telling you about. They just wrote it all out, and I can't believe they filed it in broad daylight. But anyway, Burwell, on June 8th of 2023, while Eisenberger was threatening me, he was finishing drafting the assignment of membership interest in Blue Skies Investments, LLC. Per attorney invoice docket 88-1, they charged my children $165 and then $45 to work on robbing them. Also on June 8th of 2023, there is a charge for $82.50 for Todd Burwell to review and revise the assignment of acceptance interest in Blue Skies Investments, LLC. On June 9th, 23, Burwell charged my children another $55 to email McGuire regarding the robbery by assignment with acceptance agreement of Blue Skies Investments, and then another $40 was charged for making revisions to the assignment of membership interest of Blue Skies Investments. On June 21st of 23, another $135 and $55 was stolen from my children to again revise the assignment of Blue Skies Investments membership interest, which was funded by their stolen inheritance that they were robbed of. I want to be sure you understand that Todd Burwell, Richard Eisenberger Jr., Jeffrey McGuire, Tom Pace, and Marita Walton were selling my children's inheritance, their assets, out of the Jim Pace estate and funding Blue Skies Investments, LLC, and assigning themselves as shareholders via assignment of membership interest in Blue Skies Investments, LLC. Okay? That's what they were doing. So, right now I'm going to show you about this other big scam that was done using my name. So, what I have first here to show you is what I noticed first that was alarming. I didn't notice this until last summer. I'll call this Exhibit A. Down here at the bottom it says that Eisenberger filed McCall Stern correspondence with Tom. It's down here at the very bottom. Filed McCall Stern correspondence with Tom. So I saw that and I was like, what in the world is Tom and McCall? What are they corresponding about? That's not good. Whatever that is, obviously. So back in June of 25, like 2 years later than what I was talking about today, I was going through the Madison County Chancery Clerk's land records and looking up Will's name, Jim's name, Brantley Pace's name, their grandfather, Dr. Pace. And I was like, well, if I'm seeing all this, let me look up my name. So when I did, I was in just beyond shock. So what they have here, Exhibit B, is a fake warranty deed in my name saying that I own Waverly Block J at Reunion Subdivision, that I own the whole entire block of homes, and that I also have an interest in the common ground, the common area, as in the swimming pool, as in, well, both swimming pools, the walk-in, the sidewalk pass and so forth, everything in Reunion that I'm going to be an owner of. That's what they're saying. And they have also included all these blurbs down here about oil, gas, and sand, gravel, and mineral reservations and leases and so forth. And they also talk about some weird 10-foot drainage and utility easement and a 5-foot drainage, and utility easement located along the side lot lines, all depicted on recorded plat, Cabinet D at slide 132 in Madison County Chancery Clerk's Office. So that's a fake warranty deed on me that says I own part of the neighborhood of Reunion. So since I own that, they were able to fake that. So they were able to fake this deed of trust on me that says I borrowed $510,553.00 on June the 22nd of 06. And they have me owing this in 3 months. So I owe over $500,000 by October the 1st of 2006. This is by BankPlus on Jerry Clower Boulevard in Yazoo City, Mississippi. The beneficiary to this fraud deed of trust by Mr. Attorney E. Barry Bridgeforth. He was assisting in all this, getting paid off of my identity. So you can see here the $510,553, the date of June the 22nd, 06, and the maturity date of 3 months later. They have a loan numbers, have it all faked, all done up. This is for that Reunion property I own, the whole Waverly Block J. Here they have forged mine and Will's signatures and forged a couple of notary stamps. So yeah, all that's forged. So here I have exhibit D, which is the satisfied and canceled authority to cancel. So they have me right here late paying it off. They say I missed the date. They said I paid it off on April the 10th of 2007 so that BankPlus was paid off on that date, that $510,000. And again, this is a handwritten cover page because they can't do the electronic one because that would show the real date, as in the same date Tom and McCall, about that time they were talking. So here's the letter from Barry Bridgeforth to BankPlus, the 3rd day of April 2007, big lie. The authority to cancel was, it was supposedly by Alan Butch Gary of BankPlus in Yazoo City, Mississippi. It's another fake letter. So, deed of trust, well, the second one today, but the third one on me, another fake one on me, with BankPlus as the beneficiary in my name, taken out on December the 8th of 2006. So I was real busy in 2006. Down here. You can see all that. December the 8th, 2006. Another deed of trust with BankPlus. On Waverly Block J at Reunion, Plat Cabinet D at slide 132. So I'm borrowing another $375,000 to the penny for BankPlus to benefit from. So that year I borrowed almost $900,000, or is it 900? Yes, over $900,000. Yeah, that's all obviously all fraud. So here's the authority to cancel by J.P. Morgan Chase on Waverly Block J at Reunion. Waverly Block J at Reunion in my name, authority to cancel, J.P. Morgan Chase Bank. And here is another one that I found, even though this one was dated, well, it was also dated June the 26th, July the 30th of 2003. It's a partial release, like releasing a lien. It's a fake lien that they put on some land that Will and I used to own in Canton, Mississippi. We didn't have a lien on it, but they said we did. This is with Trustmark National Bank. So we have them in here too, getting rich off me. They say that I satisfied that loan on, they said I satisfied that loan on June the 26th of 06, and they filed they handwrote the paper on July 3rd, 06. Okay, and lastly, let me show y'all more evidence of McCall Stern misbehaving with Tom Pace and BankPlus and Todd Burwell and Richard Eisenberger. Well, she billed me. She was stupid enough to send me an invoice for her behavior. She wrote that she typed up March the 12th of 2024 that I was going to owe her $52.50 for reviewing the 2006 transfer to Circle 7 and sale in 2023. A 2006 transfer to Circle 7. I don't know what anyone or she was doing in 2006, but it certainly wasn't this. And right above that, you can see that she was reviewing BankPlus records. I have no idea what records she was reviewing, except the records that they were working on to steal from me. I mean, not from me, but use my identity to steal from everybody through their insurance policy premiums. So, yeah. So if you have any questions about the scam, you can ask me, because I'm sure I didn't say that everything as clearly as I could have. I certainly don't pretend to be able to speak as well as I wish I could, but ask me anything you would like on the comments. Thank you.